count towards
Nope.
having 5 peer references.
Correct.
I have a comment, a
Yeah,
question.
Michael.
Should those letters be, or how substantive should the letters be? If we are saying, oh, it can't be just meh or more.
We send them out. So applicants just simply tell us who, and the references have to be returned to us on our form.
Oh, I see. So they're not writing the letters. You have a form that you reach out to the references. So is that a question and answer, or is it more open fields?
There's both.
I see. So you have a set practice for how you get the references.
How do you know this attorney? How long have you known them? When was your last experience with them? Rate their experience in this, rate their experience in that.
I see.
Other attorneys that we can reach out to. Yeah.
It is like a background check. Got it. I see. So this is not letters of recommendation. It's not, the person who is writing a letter that could be ghostwritten, for example.
Correct.
Got it. Michael?
Will a template be provided online, so at least there's a heads up to the individual knowing what they will entail if they become one of those references?
We do send the question. It's an electronic questionnaire, so we do send it out. We tell applicants that you're welcome to let this person know that to look out for an email from us.
Mm-hmm.
Yeah.
And the question that will be asked is something that you provide, or you do not?
What do you mean?
So the list of questions that you'll be asking to the references, do you provide to the applicants so the applicants can say, hey, these are the questions that you're likely to be asked?
We don't provide it to the applicant, but I mean, if the applicant was provided as a reference for someone else, they would know what it is already.
I see.
Yeah.
I think that was kind of Michael's question.
Yeah.
Oh,
I
okay.
mean, yeah. I kind of emphasize transparency because those questions are going to be shared amongst other people once it goes out. So, like, in my opinion, just give some questions that they will be expected, because those questions, since they're going to be uniform amongst all applicants, eventually those questions will be leaked online in one way or another. So I rather think that transparency will just be better from the get-go.
Thanks for your comments, Michael. I am looking at the clock. We got 7 minutes, so I would like us to talk about the other 2 that we haven't talked about yet. Again, I'm looking for thumbs up, thumbs down. Do we like the idea of having another certification, privacy certification from an industry recognized certifying body as being one of those? So if you show that you have a privacy certification, could that help to go towards showing that you have expertise without the exam? Thumbs up, thumbs down. Do we like this idea?
Thumbs up.
We got a thumbs up. Anybody not like the idea? We got a couple of thumbs up.
Quick question.
Yeah.
So I know time. What if the certification is expired, but you got it already?
It's a good question. So the question is, should we make this active certification, right?
I'll give an example. My CompTIA Security Plus exam score 875 out of 900. It asked me to write other exams because of the high score. There was a new rule during that time frame in which they retroactively also nullify my previous certifications, the other subject matters, and put retroactively a 3-year deadline of them not wanting to renew. There was policy, but more specifically, I think economic reasons why they want to get people to be recertified and retake the exam. But that's my hypothetical. Yeah. That's right.
I appreciate your comment. We do want to talk about the academic experience as well. So just really quickly again, because we're going to be talking about this at length during the next meeting, all of this together, all of the packages together. I would like the group to think about when we say we're going to allow, this will be one of those things that count towards showing that you have met the minimum eligibility requirement without having taken the exam certification. The question is, should that be active at the time of application? That's one option. Or, was it obtained in the preceding 3 years or preceding 5 years? That's another option. Or do we have to, or do we think about some combination, right? So, whether a certification was obtained in the last 3 years or 5 years versus is that active? I think that is something that we want to think through and clarify in our alternative to examination specs.
This is Rob. So just clarification for me. So this is only for the initial, right?
Correct.
Okay. Then I don't have a problem with that. I do think it should be an active certification. Otherwise, it's not relevant to being, laws change, lots of things change. So I think it should demonstrate that you have an active certification.
Mhm. Hillary?
I would also add that we clarify what certifying body is and what the test is, because, for example, there is IAPP and there's the SIP US. There's also the SIP foreign exam. So I'm not necessarily sure. I don't think we want to say that if you pass the SIP foreign exam, that you are an expert for purposes of the California bar. And I'm not even sure we have to think about, I know the SIP exam does include a good portion of questions related to CCPA, but does that necessarily mean that, and we have to think about, is this going to mean that you're also an expert in California related privacy laws? And I'm not, that certification does not mean that.
So Hillary, I agree with you. And I actually, again, was on the CBLS before, and I think we do need to be careful because I know a lot of people on here are on the IPP and on the board or involved in that. We don't look like we have some sort of conflict of interest where we're saying, well, we'll grandfather you if you have an active certification there. It feels a little bit weird. And so then do we get into the issue of now we have to certify these other industry recognized certifying bodies in order to recognize and identify who they are. So it is a bit of a slippery slope, and I'm not really sure how to solve that.
Yeah, I think that's right. So I think the questions here that we will discuss during the next meeting, one is, when we ask for the certification, should it be active or expired? So far, we heard more members saying it should be active. And then the next question is, do we leave it open and say broadly defined certifying body and allow for the persons who are reviewing the application to decide whether this is the appropriate certifying body or not, leave that open? Or list it out to Hillary's point, right? So even within the IPP certification, does CIPP US count, but CIPP CA does not, for example? I think that's the point that you're raising, or CIPP EU. And so, if we list CIPP, then what about CISSP? And what about, other industry, listed certification body? And I think we can guarantee that we will not have the full list. Right? Whatever list we put together as being eligible, it is not going to be complete. So I think if we do attempt to try to come up with, here's a list of eligible certifying bodies, I think we will definitely miss some that I think would be considered to be privacy specialties. So that we could probably spend hours just talking about that. So I think that those are two open questions I have noted for us to discuss and for the groups to think about during the next period. The last point, and I think we might go over 5 minutes just because I think we have to wrap up. So hopefully people can stay on for 5 more minutes. I did want to get yay or nay on the academic experience. Do we want to give some credit to those that are teaching? Especially if you are a full-time academic, right? You might not have CIPP, but maybe you are the privacy law professor at an accredited university. Do we like giving academic credit, yay or nay?
I don't see why not. I think that if they are teaching privacy law, then that should be recognized. The only issue is why only full-time? I think that some credit should be given even if you are teaching it part-time, because being able to teach full-time, it does mean a certain number of hour commitments, but then you do have some other folks who may be teaching, for example, and working in a law firm on privacy matters, and in those cases, I think they should have some credit given for for teaching privacy law, even though obviously it won't be the same amount of points or whatever as someone doing it full time, but it should be counted as well.
Okay, Adrian?
It is on the application. Just generally, I don't know if that's known. So applicants can already, if they're teaching at a law school, they can use that to satisfy the entire 45 hours.
I see. So, and I think that was what we were trying to address, right? Is that if you are teaching at a law school, you could use that to basically not have to meet the continuing legal education requirements. So that item 5 here is basically saying that if you're using the fact that you are a professor to get out of the legal education requirements, you cannot also use that to get out of the exam.
So you would need that plus your 45 hours.
Correct. That's right. So it's either to meet the CLE requirement or to meet the exam requirement if you're teaching. I think that's what that number 5 is meant to address, exactly that point. We are now out of time. So let's go to next steps. So thank you very much. I think this we had a very, very productive group meeting. I appreciate all of the members who have spent countless hours in preparing, researching, and presenting on all of the above topics. Next step will be, the next meeting will be on October 24th, 2024. And Janelle and Adrian here, we have the next few meetings so that you have it on your calendars. For the October 24 meeting, what we'll be doing is that the chair and the vice chair, that's Ryan and me, will be assisting the staff in developing a proposal for review and approval to be presented to the CBLS during the upcoming PLG meeting. So at the close of today's meeting, there will be a follow-up email from Janelle summarizing today's meeting and the assignments along with the due dates. So please keep the October 24th meeting on your calendars. And what I understand will be we'll be discussing both the exam topics, which we presented during the last meeting, as well as today's topics, which included the task and the experiences requirements, the continuing specialty legal education requirement, and also the alternative to exam. So all of those will be revisited and discussed and voted on, and hopefully the group will agree on the full package of the presentation that we will be presenting and submitting to the CBLS during their next meeting for approval. That's the next step. Does anyone have questions or comments? Okay. If there are no other questions or comments, this concludes the all open session items. There are no closed session items on today's agenda. I hereby adjourn today's meeting. Thanks very much.
Thank you.